Hello, my name is Kevin Uphill. I'm Chairman of Avondale Corporate. Today we have a talk on legal complexities of buying or selling a business from Emma Cameron of Veale Wasbrough Vizards. The market remains highly competitive. We spend a lot of time crafting good heads of terms, but it's the legal advisor's job to make sure these turn into quality agreements that reflect the basis of the arrangements between the parties. Emma.
Thank you, Kevin. So as Kevin says, I'm going to cover the legal complexities of buying or selling a business. I'm a partner in the corporate team at Veale Wasbrough Vizards, so advising clients on buying or selling a business is very much something that I do on a day-to-day basis. So I thought I'd begin by just giving some examples of quotes from clients who've gone through a corporate transaction. And if you could perhaps keep those thoughts at the back of your mind as I go through the webinar, and then I'll pick them up and put them in context at the end. So to run through the quotes, I didn't have time to keep my records. I thought I'd save the cost, but it was only 5% of the shares. I brought my funders in late to save on costs. So what I propose to cover today is preparation, different deal structures, finalising the deal, what the process involves, what each party requires and why, and then I'll finish off by giving some practical obstacles that can sometimes arise in a transaction and hopefully give you a few tips so that you can prevent them arising in any transaction that you may do. So beginning with preparation, really what we're talking about here is preparation in a legal context and preparation that the seller can do. And this can cover a wide range of things, from something as simple as making sure you do have contracts with customers and suppliers, that they're signed, that they're dated, and you can actually easily access them so that you can provide them to the buyer when they're doing their due diligence. It can also mean making sure that those contracts are up to date and take into account recent changes in law. So for example, make sure that if you sell things at a distance, the cooling period is the right length of time. It could be more complex preparation. For example, very often there may be properties held by the trading company that actually aren't needed for the trade and need to be transferred out prior to the sale of the target company. And all that preparation is worthwhile to the seller because hopefully it will reduce the need for the buyer to reduce the price if it finds issues with the target company. It will also make the process smoother for the buyer, and that will help the buyer and hopefully reduce fees on both the buy side and the sell side. Preparation is even more key if you're in a situation where the buyer is funded either by a bank or by some private equity investors. Quite often a buyer, particularly a buyer who's in the same sector as the target, will understand the commercial reality of the target's business and may be more likely to take a view on some issues. But if the buyer has a bank or a private equity house behind it, then the bank or the private equity house will have a much more sort of tick box attitude to funding the deal and won't take a view on things. So it's even more important in those situations for the seller to be well prepared. The other thing to settle on early on is the structure. And you'll hear various terms bandied about. You might hear management buyouts, management buy-ins, combination of the two, which sometimes refer to as bimbos. But effectively, from a legal perspective, there's sort of two ways that a business can be transferred, either by a share sale or by an asset sale. And the difference really is that in a share sale, the sellers are the shareholders of the shares. They sell the shares to the buyer. So the buyer acquires the shares of the company and therefore gets the company and everything that the company has within it, sort of warts and all. And there's benefits and disadvantages of that. With an asset sale, the seller is the company and the company is selling various assets, perhaps all of its assets or certain assets to the buyer. And again, there's pros and cons with that route. The benefit from a legal perspective of acquiring the shares is that you do get everything in the company. So there's less risk of acquiring a company and not having everything in there that you need in order to operate the business. The problem is, though, that you do get everything. So there might be some horrid liabilities there that you don't really want. So the due diligence carried out by a buyer, if it's doing a share purchase, may be more thorough. The protections in the share purchase agreement will probably be longer than the protections in an asset purchase agreement. With an asset sale, the buyer has the benefit that it can pick and choose what assets it gets. But then you need to make sure that each asset is properly transferred over in accordance with whatever rules may apply to that transfer of the particular asset. So if you've got real property, then you need to make sure the land registry is updated. If there's intellectual property, for example, trademarks, then you need to make sure those transfers are updated at the trademark registry. So there are pros and cons of each route. And especially at the moment, very often the decision as to whether or not to do a share sale or an asset sale is very much tax driven. It tends to be the case that for a seller on a share sale, the tax position is so much better than on an asset sale that I'd say that at the moment, about 90% of the deals that we do are share sales rather than asset sales. The other thing to bear in mind is that your lawyer will have to do things differently on each route. So I flagged up on this slide two particular issues. One is in relation to contracts. So if you've got commercial contracts, say with customers or suppliers, then you will need to make sure if you do an asset sale that those contracts are assigned or novated over, and that is likely to need the consent of the counterparties to those contracts. With a share sale, in theory, the contract will stay with the company, so you don't need consent. However, do be careful that in some cases contracts will have what's called a change of control provision in them, in which case you will actually need to get the consent of the counterparty. And that is something that when you're doing your preparation as a seller and you're looking at your contract situation, you should definitely check the change of control provisions in your contracts. The other thing to flag up is if there's employees in the business, which is likely to be the case, a buyer who's doing an asset purchase may think, well, I can choose not to bring the employees over. That's not really the case, because if there's what's called an economic undertaking transferring over, which is likely to be the case, then the employees will have the benefit of the transfer of undertakings protection of employment regulations, which effectively mean the buyer has to take on the employees and has to consult with the employees about any changes it may want to make. So once you've agreed the structure, whether it's a share sale or an asset sale, the next thing to do will most likely be to put in place some heads of terms, which Kevin referred to in his introduction. And it is really important to make sure those heads of terms are well thought through. Most of the heads of terms will not be legally binding, so clients sometimes ask, well, what's the point in having them? Is it worthwhile spending the time and money doing them? And I think that in all but the most simple of cases, it is worthwhile to have them. The heads should set out in bullet point format the key terms of the deal, so what's being sold, what's being paid, when is it being paid, is it all up front, is there any element of deferred consideration? It's amazing how often people can leave a meeting thinking they've sort of shaken hands on a deal, and actually when you try to distill the key terms of the deal into a few bullet points, people realise they're still quite far apart. And before the buyer or the seller starts throwing lots of money at advisors' fees, it's really important to bottom out any key issues in the heads. Some of the provisions of the heads of terms should be legally binding. So for example, if there hadn't been a confidentiality agreement signed up until this point, you could wrap some binding confidentiality provisions into the heads, which will give the seller comfort that when the buyer finds out information about the target, it wouldn't misuse that information. From the buyer's perspective, it may well want some binding exclusivity provisions, because the buyer is not going to want to be throwing lots of money at legal fees if actually the seller is still talking to other potential buyers. Each party may want some sort of cost protection in the heads. That can be quite difficult to draft, and even if it's drafted and in the head, it can be quite difficult to rely on, because effectively each side will want something along the lines of, if the deal falls apart because of fault on the other side, we want our costs covered. And it can turn into a bit of a sort of slanging match about whose fault it really was. So quite often where you end up is each party agrees just to bear its own costs, and then hopefully common sense will prevail and people won't rack up too much costs. The other thing that is helpful for the heads to contain is a realistic time frame as to when the deal is going to complete. And I say realistic because in my personal experience, I think if deadlines are too tight, they get missed. It sets a precedent for all deadlines to be missed in the transaction. And actually sometimes those deals can take longer to complete than a deal where you have a sensible timetable set out. So once the heads are signed, the next thing to do will be for the buyer to commence its legal due diligence. It's likely to have done financial due diligence in order to come up with a price for the business, but now it will start looking into all sorts of legal aspects of the target. So employees, contracts, intellectual property, real property, you name it, they'll be looking into it in detail. Hopefully, if the buyer doesn't immediately come across any sort of red flags in doing the due diligence, the buyer's solicitor will start to prepare the purchase agreement. And usually it is the buyer's solicitors who prepare the purchase agreement, the first draft of it, for the simple reason that the buyer will want lots of protections in that agreement, and it doesn't really make much sense for the seller's solicitors to do it, because they either won't put in any protections or they're sort of second guessing what the buyer will want. The purchase agreement will be pretty long, typically at least sort of 50 pages, sometimes up to 100 or so pages, but effectively it has two main aims. Firstly, to reflect the commercial deal, so similar to what the head of terms did, but in much more detail. And secondly, to allocate risk between the parties, and I'll come on to how that is done in a few slides' time. There'll be lots of negotiations and meetings, but effectively you will eventually end up, hopefully, with the final form documentation. And just a note on that, the purchase agreement will contain what's called an entire agreement clause, which basically says anything that's not in that agreement, so anything that's in another document or anything that was said in the negotiations, is effectively irrelevant. So you need to make sure any key terms are in that final documentation. So if buyer and seller go down the pub to try and sort out some commercial issues, which can very often be a sensible way to resolve some commercial issues, if, for example, the seller says to the buyer, don't worry about that issue, if that crops up, I'll see that you're all right for that, please tell the solicitor so that they can cover that off in legal terms and put it into the purchase agreement. The other thing just to flag up on the negotiations is the time commitments. The advisory team should take a lot of the workload away from you. That's what they're for, but they will need instructions, and especially as the deal nears completion, there'll be meetings and calls that your involvement will be essential for. So I mentioned that the purchase agreement tries to allocate risk between the parties. So I thought it would be helpful to firstly think about what the buyer wants, and then secondly think about what the seller wants. So from the buyer's perspective, there's sort of three main areas of protection the buyer will want. Firstly, the buyer will want to know that what it's getting is what it thinks it's getting. It will also want to know it's paying the right amount of money for the business. And it will also want comfort that on the day after completion, the seller is not going to set up in competition around the corner for the business that the buyer just paid good money for. So taking those in turn, the buyer will want to know that it's getting what it thinks it's getting, and the main way of doing that is through the warranties. And the warranties are a long list of statements about the business. So to take an example, it may say there are no employment claims, and to the extent that there are some employment claims, the seller will need to disclose them, and we'll turn on to that in the next slide. If the buyer has particular concerns about an aspect of the business, it may ask for what's called an indemnity, and an indemnity is a simpler way for the buyer to sue the seller effectively. With a warranty, the buyer has to show loss, and it can be a bit of a long-winded process. Indemnities is an easier way for the buyer to sue. When it comes to the buyer trying to work out if it's paying the right amount of money for the business, there's a few things it can do. Firstly, it can not pay all the money at once, so pay a sum at completion and then have some deferred consideration, perhaps a form of earn-out, which is where the future deferred consideration is dependent on the profits of the target business. They can be tricky to draft because sometimes the profits will, for example, be increased by the fact that the target is now part of a bigger organisation. There'll be cost savings at HR and accounts level. And is it fair that the sellers get the full recognition of those savings when actually they're not thanks to anything the seller may have done? But that is one effective way for the buyer to make sure it's paying the right amount of money. The other thing the buyer may do is put some money aside in a retention account so that it knows that if there's claims that arise, then there's money there to cover those claims. And the buyer will also want to try and be as accurate as possible about how much the business is worth. It can be very difficult for a trading company in particular to draw a line in the sand at completion and say the company is worth X amount. So there's a couple of ways that that can be dealt with. Very often after completion there'll be what's called completion accounts prepared, which look back to the date of completion and effectively give a more accurate valuation of the company. And to the extent that too much has been paid for the business, then there may be a clawback from the seller, or more likely there'll be money in a retention account sitting there to cover that amount. Or the other thing is that you could choose a date in advance of completion called a lockbox date and agree that only certain payments will be made out of the company between that date and completion. And to the extent that any payments are made that aren't permitted, if there's any leakage as it's referred to, then that would be for the seller's account. And then lastly, to protect the buyer from the seller competing with the business, there should be some robust restrictive covenants. So preventing the seller from poaching employees, poaching customers, and setting up in competition. The restrictive covenants can't be too restrictive or they won't be enforceable, but you should be able to get some pretty robust ones in there. From the seller's perspective, things are sort of more simple. The seller will most likely just want as much money as possible and on a risk-free basis. So if the seller is in the lucky position, and hopefully it will be, if Avondale's been doing its job and has got a few offers going and there's a bit of competition, then the seller may well be able to think, well, I've got a few offers here. Is an offer which is for more money but has an element of earn-out, is that more attractive to me than an offer where perhaps there's less consideration overall, but it's all paid at completion? And that will depend on the risk profile of the seller and the stage of life that they're at, perhaps. If there is any element of deferred consideration, then the seller should do some reverse due diligence on the buyer and check that the buyer will actually be able to pay that money. And the seller would be well advised to ask for some security, so for example a parent company guarantee, or maybe some charges over shares in another group company, but something to give the seller comfort that actually there is money there to pay the deferred consideration. The other thing the seller will want to do is to reduce the likelihood of being sued, especially on those warranties that we referred to earlier. And that is where it will be very important for the seller to go through the warranties with their solicitors and produce any exceptions to those warranties. So to follow up on the example that I gave earlier of the warranty saying there aren't any employment claims, if there were, then the seller would have to give full details about that claim to the buyer, and that effectively has the result that the buyer is on notice about that issue, and that process actually helps the buyer because then the buyer is in the position where it can choose to walk away from the deal if it's a massive issue. It can reduce the purchase price, it can ask for an indemnity protection. The buyer has options, and generally speaking the buyer would want to know about an issue before completion than after completion, when all it can do is sue on the warranties. The other thing that the seller will want to do is put some limitations on its liability. It's not going to want to be on the hook to be sued forever and a day after completion. It wants some time limits, it wants some financial caps as well. So that's all part of how the negotiation will work on the risk allocation, and hopefully you will eventually end up with a purchase agreement that both sides are happy with. So that leads me on to some of the practical obstacles that can arise on a deal, and sometimes unfortunately there is just that gulf in a risk allocation, and the buyer perhaps just won't accept that it has to take some risk on what it's buying, and the seller thinks it can just take the money and run off into the sunset. It can be very difficult to resolve those issues if they're that fundamental, but hopefully through the negotiations of the purchase agreement and being well advised both by the solicitors and the corporate finance advisors, you can get over that. The other thing that sometimes happens is the awkward other lawyer, and I would obviously hope that that would never be our firm, but I don't really mean there the lawyer who's trying to do the best for their client, because you expect that and you almost sort of want that because you want to have a sensible discussion with the other side. But really the problems can arise where a lawyer is not used to doing corporate transactions, and that can really delay things and make things very painful for the other side, and it's not really very fair because it can rack up costs if the other lawyer doesn't know what they're doing. The other thing that can sometimes arise is where you've got a third party involved. It's very easy if it's just the buyer or the seller for things to go through quite smoothly. As soon as you have a landlord or a funder or a key commercial contract that requires the consent of the counterparty before the transaction can proceed, then things are out with your control. So that all forms part of the seller's due diligence and preparation, and to make sure that any issues that could arise with third parties are addressed early on, so it doesn't delay things as you get near to completion. Sometimes there's issues if you have a huge difference in size between the buyer and the seller. Quite often, for example, you may have a PLC buyer buying an owner-managed business, and it can be quite difficult for the PLC with its in-house legal team and company secretarial department to understand that an owner-managed business is run in a very different manner, and that can sometimes be difficult. And the other thing that can arise is where you have a buyer that's from a different country. If you do have a foreign buyer, then in your heads of terms, it will be very important to agree that English law governs the transaction. If it's an English target company, then usually you should be pushing for English law. But there's more to a transaction than just the law. There's an attitude in the way that the transaction is conducted. So, for example, if you have an American buyer, then they may well want indemnities on everything. And in the UK, the practice would only be to give indemnities on specific issues. So if you do have a foreign buyer, it can be worthwhile to explore that type of issue at an early stage. So just to finish, I'm going to put the quotes that I gave at the beginning into context. The first was, I didn't have time to keep my records. So the result there was that unfortunately the deal did fall apart because the buyer lost confidence in the business. Even though financially everything sort of stacked up, the buyer just didn't have faith that the business was properly run and organised. I thought I'd save the cost. That was a seller of a telecoms company, and its T's and C's weren't properly drafted, and it meant that the buyer had concerns about liability, so the seller ended up giving indemnities to the buyer on that deal. It was only 5% of the shares. This was where an owner had given a minority shareholding to some employees who had since left the company. And then what happened was that those ex-employees held the majority shareholders to ransom and actually got more than their fair share of the sale proceeds. So please make sure, if you are thinking about having minority shareholders, get your articles of association checked so that the minorities can be dragged into any sale to a third party. They will get the same price per share, so they shouldn't be prejudiced, but it just means that they can't hold the majority shareholders to ransom. And finally, I brought my funders in late to save on costs. That I have quite a lot of sympathy for. It can be very difficult to know when the appropriate time is to bring in funders. Bring them in too early, they'll be crawling over everything and perhaps delay the deal. Bring them in too late, and they may well have legitimate comments in the documents that you'll then need to sort of run around trying to take into account just before completion. So I would say there it's a case-by-case approach and attitude, and do speak to your advisors who'll be able to sort of tell you when the best time to bring them in will be. So that covers everything that I wanted to say. My details are obviously on the slides, and do feel free to get in touch if you have any comments or queries.
Emma, thank you. That was a fantastic talk. I reckon that will go viral. We've had a few questions actually. The first one is locked boxes. What are the trends on locked boxes? Increasingly used or less?
It's a very interesting question actually. For years and years we didn't really see them at all. And then a few years ago, they were creeping back into sort of being used more commonly. And then I'd say in the last year or so, I haven't seen them so much. So, I mean, I don't know, obviously, that reflects the corporate market as a whole, but certainly the deals that we've seen through, we had a series of them a year or so ago where lockbox seemed to be in favour, and more recently, not so much.
And what do you think the advantages are of them?
Well, I think the simplicity in a sense, because completion accounts policies can be notoriously difficult to draft depending on what type of company it is. I think it does depend on what that business does. For example, one deal where I did a lockbox and I think it really worked, the target company didn't have a lot of money coming in and out of it. It was a few big contracts and it was very easy for the lockbox mechanism to work. I think if you have a company that is highly trading and there's a lot coming in and out, perhaps completion accounts may be the answer. But it's a case-by-case basis, really.
Great. Okay, and the next question from a buyer is that a seller's pushing to have warranties periods reduced. Is that a common trend at the moment?
I think over the years they have actually got shorter, not for tax. Tax, unfortunately, does tend to be sort of stuck at the 7 years because that's how long HMRC can look back. I mean, certainly when I started my career, which is quite a long time ago now, 3 years was not unknown. 2 years probably maybe where you would end up for warranty period and general claims. Now I'd say 18 months is pretty common. We see that quite a lot, and certainly sometimes 12 months.
Well, certainly that's a trend we're seeing. We could talk about this all day, Emma. Thank you very much. Much appreciated.